Paris. Okay, awesome. Where's Paris? Hi, come on up. Hi, we have an intern with us today.
If you want, you
Yes. Hi, you can have a seat here. Yes. And I'll make sure you're introduced so everyone will know you and they can answer any questions you may have. All right, how do you say your last name?
Marciniak.
Marciniak. Okay. All right, the court is calling 2025 CR 011437, State versus Adam James Marciniak. Could I have parties announced?
Rick Pena for the state of Texas.
Don Flannery for Mr. Marciniak.
And are you Mr. Marciniak?
Yes, Your Honor.
And counsel, is this going to be an application?
Yes, Your Honor.
All right, probation, it's an application. Counsel, have you received all discovery? Did you review it with your client?
I did, and I have.
Court will find that the state is in compliance with discovery. Mr. Marciniak, did you review the document entitled Application for Deferred Adjudication with your attorney? Did
Yes,
you
I
understand
did,
it
Your
and
Honor.
sign it?
Yes, I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
Bless you. State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on the lesser included misdemeanor offense of assault causes bodily injury, family member.
Any objection?
No, Your Honor.
All right, Mr. Marciniak, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, Your Honor.
All right, the state is proceeding on the lesser included offense of assault causing bodily injury to a family member as a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I did, Your Honor. Yes, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
I understand that, Your Honor. Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Mr. Marciniak, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Absolutely not, Your Honor.
Anyone promised you anything other than the plea?
Nothing, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trials. To jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
I do, Your Honor, and I did. Yes.
According to the plea, the state is proceeding on the lesser included offense of assault causing bodily injury to a family member. There's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
I understand that, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
I do understand.
All right. And defense, is that the plea?
Yes, Your Honor, it is.
State, is that the plea?
Yes, it is, Your Honor.
And do you understand that to be your plea?
Yes, I do, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours community service restitution, anger management, TAP evaluation, follow TAP recommendations, and parenting classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I do, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence this exhibit one with all attachments.
No objections, Your Honor.
All right, and state, have you spoken with the complainant?
Yes, we have, Your Honor.
All right, you may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I do, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, this has been a long process for him. He and a lot of things have gotten resolved. He had an outstanding divorce and custody issues. All that's been resolved, and I think that this is the best scenario for him, particularly with the no contacts. And I think it's going to be good for the CW, and I think it's good for him. And we're happy that the state has given us the opportunity to enter this plea.
All right. So they're asking for parenting classes. So I'm assuming you have children?
I have one child, yes.
And is that with the complainant?
Yes, Your Honor.
And are you all communicating through a parenting app? How are you
There's a parenting app, the daycare, my parents, she drops them off on Friday. I pick them up the next Friday. There's been successfully no contact for over a year. I have a restraining order on the complainant as well. I have no interest in ever talking to the complainant ever again.
All right, but you all do have contact through the parenting
Yeah, through the app, close app, and my parents being kind of an intermediary party to, schedule birthdays and holidays and whatnot.
State, do you have any objection to the defendant having contact with the complainant through the parenting app and through third parties? Okay.
Thank you, Judge.
All right. Are you employed?
Yes, I work with Lyft currently and I go to school full-time at UTSA.
Oh, what are you studying at UTSA?
I'm a business management major and I'm a senior.
And a singer?
A senior.
Senior, okay. I was like, a singer, what are you, yeah. All right. All right, this is what the court is gonna do. The court is gonna sentence you to a $1,500 fine. That will be probated. There appears that this maybe was a contentious divorce with child issues. The court is gonna sentence you to 14 months deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment or within 45 days. There's to be no employment as a home healthcare provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. They should have probably ordered parenting classes for you with the custody issues. If they did, you turn those into probation and that will count towards 50 hours of community service restitution. If, however, that hasn't been completed, I'm ordering parenting classes, and upon completion, 50 hours of community service hours will be deemed satisfied. The remaining 50 hours of your community service hours will be deemed satisfied upon graduation. There is to be a TAP evaluation out of custody. If you're drug tested today, what will the results be?
I smoked marijuana 2 months ago. I don't know if it would,
So here's the thing, while you're on probation, and your attorney will tell you this, you're not allowed to use marijuana unless you have a prescription for it, and you're not allowed to drink alcohol while you're on probation.
Understood.
Okay, so TAP evaluation out of custody, follow recs. If they're recommending inpatient treatment, we'll start with supportive outpatient treatment. There's an affirmative finding of family violence. There's to be no contact with the complainant. And I'm sorry, it's not no contact, it's no in-person contact with her. Probation contact with her is allowed through third parties and the parenting app. If for some reason there ends up being a graduation or something for your child, just let probation know. And I don't think there would be any objection for you appearing. Just make sure if you are appearing at that you have third parties there for witnesses.
Yeah, he's 2.5, so it's going to be a while.
Oh, well, I don't know. They're starting them at going to school at 3, but okay. And there's to be field visits 1 time per month for 2 months. Let's see. Probation, is there anything else?
What is a field visit?
So they're
Okay.
gonna come and check out your house.
Okay.
Probation, anything else? Is there anything else that you need from the court to be successful?
I don't think so, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I understand, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. And this is just a piece of advice for you, right? When there are issues, when people break up, this is what I've discovered on the civil side. Don't involve third parties. Don't ever let a girlfriend pick up your child or be at a child exchange. That's going to cause problems. You understand?
I understand.
All right. Good luck to you.
Thank you.
Thanks, Judge.
You're welcome.
May I be excused?
Yes.
Thank you.
Anyone else ready? Okay.
This case right here is a textbook example of how family violence charges don't just end in court, they follow you into every part of your life. Adam James Marciniak didn't come in shouting, he didn't argue with the judge, and he didn't deny what happened. In fact, he entered a plea to a lesser included offense, assault causing bodily injury to a family member, a misdemeanor. On paper, that might sound lighter than a felony, but legally and practically, this is still one of the most damaging convictions a person can receive. Because the moment the judge makes an affirmative finding of family violence, everything changes. First, and this is huge, Adam is now permanently banned from owning or possessing any firearms or ammunition, not temporarily, not while on probation. This is a lifetime federal restriction. One conviction, and your Second Amendment rights are gone. Second, and arguably even more impactful, he is now legally blocked from ever being designated as the primary custodial parent of his own child. That's not emotional. That's not opinion, that's the law. Even if he becomes the best father in the world from this point forward, this finding will always sit in his record. And what makes this case even more intense is the backstory. This wasn't a random act of violence. This came out of a contentious divorce and custody battle, where emotions were high, communication broke down, and a personal conflict escalated into a criminal charge. Adam tells the court he hasn't had direct contact with the complainant for over a year. They communicate through a parenting app. His parents act as intermediaries. He even has a restraining order against the complainant himself. This is the kind of situation where two people no longer trust each other at all, and the court becomes the referee of their lives. The judge tries to be practical. She allows contact only through third parties. She acknowledges the parenting app, but at the same time, she lays down strict conditions: 14 months of deferred adjudication, random drug testing, anger management, parenting classes, community service, no alcohol, no marijuana, no working with minors or home health care, and full compliance with probation. This is what a second chance really looks like in the justice system. It's not freedom, it's freedom under surveillance. And here's the real lesson for anyone watching. Family violence cases are not about just winning in court. They're about losing access to parts of your future. You don't just pay a fine. You don't just do probation. You lose rights. You lose credibility. You lose legal ground in custody forever. And the judge makes that crystal clear when she warns him, if this deferred adjudication is ever revoked, the court can sentence him to a full year in jail and a $4,000 fine, and the original plea won't protect him anymore. So the real question for you watching this is, was this just a moment of anger in a bad relationship? Or was this the kind of behavior that justifies permanent legal consequences because one argument, one incident, one bad decision? And now this man's parental rights, weapon rights, and criminal record are changed for life. That's not drama, that's real-world accountability. And if you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments. Do you think the punishment fits the situation? And don't forget to subscribe for more jaw-dropping courtroom breakdowns where one decision can change everything.